AI is developing at a dizzying pace, but that speed brings up a huge question. How do we make sure it's safe and fair without killing the very innovation that makes it so powerful? This analysis, which was inspired by a commentary produced under the scientific oversight of Professor Vihar Kiskinov, is going to tackle that exact problem by digging into the EU's ambitious AI Act.
You know, at its heart, the entire problem boils down to one simple, almost impossible question. How do you regulate a technology when its most critical parts are also its most valuable secrets? This is the central paradox that every government trying to write rules for AI is wrestling with right now. So let's break this paradox down. On one side, you have regulators. For them to do their job, to check for bias, to guarantee safety, to protect our rights, they absolutely need to look under the hood. They need to see the source code and the training data. But on the other side, that exact same information is a company's secret sauce. It's their intellectual property, the thing that gives them an edge. It feels like you can't have one without giving up the other. And that, right there, that fundamental clash, is what we call the AI regulation paradox. It's this high-stakes balancing act between the need for transparency and the need to protect confidentiality. So how on earth did the European Union try to solve it? Well, their answer is something called Article 78. The best way to think about it is like a secure legal vault. It's a special mechanism that allows companies to give regulators the keys to their most sensitive information, and in return, they get a powerful, legally binding promise that those secrets will be kept safe. This whole concept is really the linchpin of the EU's entire approach.
So, let's take a look inside this legal vault. Let's figure out how it works, what exactly it's designed to protect, and, most importantly, who holds the keys.
You know, this vault wasn't just built overnight. Its protections were actually beefed up over several years of intense debate. It started as a pretty limited idea back in 2021, but then its scope grew and grew to cover pretty much everyone involved in AI. They added crucial protections for things like classified information and brought in the idea of data minimization, which basically means regulators can only ask for what is absolutely necessary. This whole evolution was really about one thing: building trust in the system.
So, what's actually being locked away inside this vault? What kinds of secrets are we talking about here?
The protections are, well, they're incredibly broad. You have the obvious stuff like intellectual property and trade secrets, and the law explicitly says this includes source code. But it goes way beyond that. It also covers sensitive information related to national security, things from ongoing criminal investigations, and even classified government data. The goal was clearly to create this comprehensive shield for almost any kind of sensitive information you could imagine being shared. Okay, so who's on the hook for protecting all these secrets? The short answer is pretty much everyone. This isn't just a rule for the big EU commissions. It applies to national authorities in every single member state, to the independent auditors checking on high-risk AI, and, this part is key, to literally any person or company involved in applying the AI Act. That means providers, researchers, even some users. They're all part of this chain of confidentiality.
Now, a vault that never ever opens isn't very useful, right? Confidentiality can't just be a brick wall that stops regulators from actually doing their jobs. So, the next logical question is, when does the vault unlock?
There are a few master keys, but they're designed for very specific, very critical situations. Information can be shared if it's needed to protect public health and safety, for example, or to carry out an official investigation under the AI Act. It can also be unlocked if it's essential evidence in a court case. The system even tries to strike a balance to protect legitimate whistleblowers while also setting really careful rules for law enforcement access.
And this is absolutely crucial. Even when one of those exceptions might apply, the vault doesn't just swing open. No way. There are powerful safeguards built in. A company has the right to be heard before its secrets are shared. They get to make their case. And if a regulator still decides to go ahead, that decision can be challenged in court. This judicial review is really the ultimate check and balance on the whole system.
The EU's legal vault is a really unique approach to this problem. So how does it stack up against what other major players around the world are doing? Let's take a look at the Global Balancing Act.
When you look at them side by side, you see three completely different philosophies at play. You have the EU, which is all about regulated access. Companies share secrets with the government, and the government is legally bound to protect them. Then you have the US, especially California, which leans hard into public transparency. The idea is to force companies to disclose information to the public as the main tool for accountability. And then Canada takes a third route, basically protecting secrets by limiting what companies have to tell the public in the first place. These are three very distinct answers to the same fundamental question.
So, the EU's legal vault is a really clever attempt to solve the AI regulation paradox. It tries to build a system of trust between the people creating AI and the people regulating it. But it leaves us with one massive, lingering question. As AI gets more and more powerful, will this legal vault be strong enough to balance our need for progress with the absolute necessity for protection? That, right there, is the defining challenge for the future of AI.